Hello everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. In this video, we're going to talk about Supreme Court rules courts can't review visa revocations. The U.S. Supreme Court has ruled that courts cannot review visa revocations, a decision that reshapes the legal landscape for immigrants and their rights within the immigration system. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. Supreme Court strengthens executive power over immigration with unanimous decision. The U.S. Supreme Court issued a significant ruling on Tuesday, unanimously deciding that federal courts lack the authority to review decisions by immigration officials to revoke previously approved visa petitions. This video marks a fundamental shift, consolidating executive power over immigration policies and limiting judicial oversight. Writing for the court, Judge Ketanji Brown Jackson explained that visa revocations are discretionary actions by the Department of Homeland Security, as explicitly outlined by Congress, and therefore fall outside the scope of judicial review. Implications for Trump's immigration agenda. The timing of the decision coincides with a rise in political rhetoric on immigration. Former President Donald Trump has made immigration enforcement a cornerstone of his potential second term, and one of his latest social media posts, vowing to end birthright citizenship, reinstate a travel ban targeting certain countries, and launch what he describes as the largest domestic deportation operation in American history. This Supreme Court decision strengthens DHS's authority to revoke visas without judicial interference, a power that could be critical to implementing Trump's proposed measures. Potential for abuse. Immigration advocates warn of broader consequences. Immigration reform advocates have raised concerns that this ruling could allow for widespread, unchecked visa revocations under future administrations. While constitutional safeguards remain in place, such as a ban on revoking visas on religious grounds or without due process, critics argue that the decision gives DHS unprecedented freedom to enforce broad policy changes through visa revocations, raising fears of potential abuses. Judicial oversight and remaining safeguards. Judge Jackson highlighted certain protections that are still available to visa applicants. Individuals whose visa approvals are revoked can file new applications, and federal courts retain jurisdiction over initial visa denials. Jackson referred to this as creating room for mercy in the system. However, critics contend that such remedies offer limited practical relief, especially during periods of aggressive enforcement. Resolving legal uncertainty. This unanimous decision resolves a split among federal appeals courts, clarifying the legal landscape over whether judges can review visa revocation decisions. The ruling will have a far-reaching impact on immigration cases, particularly those in which DHS discovers disqualifying information after approving a visa. By upholding DHS discretion, the Supreme Court consolidates the executive branch's dominance in immigration decision-making. Broader context of executive power. This decision aligns with a broader trend of judicial deference to executive authority on immigration matters. It underscores the balance of power between administrative discretion and judicial oversight, strengthening the administration's ability to enforce immigration policies without interference from the courts. Critics and advocates alike recognize the ruling's potential to shape the future of immigration enforcement in the United States for years to come. This ruling limits judicial oversight of visa revocations, highlighting the growing power of executive authority in immigration matters. That is all for today in this video. What are your thoughts on this? Please let us know in the comment section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to our channel US Immigration News. We hope you are doing great. In this video, we are going to talk about Supreme Court rules courts can't review visa revocation. The US Supreme Court has issued a landmark ruling that federal courts do not have the authority to review decisions by immigration officials to revoke previously approved visa petition. This unanimous decision delivered by Judge Ketanji Brown Jackson solidifies executive control over immigration policies by clarifying that visa revocation fall within the discretionary powers of the Department of Homeland Security as authorized by Congress. The code stands mark a significant limitation on a judicial oversight, consolidating the executive branch authority in immigration enforcement. The ruling comes at a time when immigration remains a hot topic, particularly in light of former President Donald Trump's proposed immigration agenda. Trump has made enforcement a key aspect of his potential second term, owing to end right citizenship, reinstate a travel ban, and initiate a massive deportation campaign. The decision bolstered DHS power to revoke visa without court interference, a tool that could prove crucial in advancing these proposals. However, the decision has raised concern among immigration advocates who warn that it could lead to unchecked visa revocation under future administration. While there are constitutional protections in place to prevent revocation based on a religious discrimination or without due process, critics argue that the ruling grants DHS significant latitude to enforce sweeping policy changes via visa revocation, raising the potential for abuse. Judge Jackson did acknowledge some remaining safeguards, such as the ability for visa applicant to reapply if their visas are revoked and federal courts retaining jurisdiction over initial visa denial. She referred to this as creating room for mercy, yet critics contend that these options offer limited practical relief, especially during period of aggressive enforcement. The decision resolved a legal uncertainty that had emerged from a conflicting ruling in a federal appeals courts, providing clarity on whether visa revocation can be revived by judges. It is expected to have a far-reaching implication for immigration cases, particularly those where DHS uncovers disqualifying information after a visa has been approved. This ruling aligns with a broader trend of judicial deference to executive power on immigration matters, reinforcing the balance of power between administrative discretion and judicial oversight. Strengthens the administration's ability to enforce immigration policies with a reduced interference from the courts, a development that will likely influence US immigration enforcement for years to come.